Welcome to The Explainer. Today we're diving into what is essentially the ultimate high-stakes clash between two foundational pillars of our legal system, professional politeness and fierce, no-holds-barred client defense. Now you might be wondering why this matters. Well, it matters to every single one of us, because if you are ever in the hot seat, you need to know exactly how far your lawyer can legally go to fight for your life and liberty. So we're going to look at a landmark Supreme Court of Canada decision that forces us to examine exactly that. And right off the bat, I love this quote from the source material. Trials are not, nor are they meant to be, tea parties. And you know, they really aren't. The courtroom is, at its core, a battlefield. It's a crucible where serious disputes are resolved. So while it definitely requires order, it's not meant to be a polite social gathering. It's an adversarial system by design. Which brings us to a really provocative question. Where exactly is the line between fearless lawyering and professional misconduct? Like, when does passionate defense cross over into sanctionable incivility? That question is the central philosophical friction of our explainer today. And to truly understand it, we have to look at one of the most explosive trials in Canadian history. Okay, let's dive into this with Section 1, the Brie X courtroom drama, a high-stakes mining fraud trial. To get why this is so important, we've got to set the stage with the background of this infamous scandal. $6 billion. That is a massive number. That's how much the Brie X collapse cost investors. It was literally one of the largest mining frauds in capital markets history, just wiping out fortunes when claims of a huge gold discovery proved to be utterly false. In the fallout, the Ontario Securities Commission charged a man named John Felderhof. Facing immense pressure, Felderhof hired a defense lawyer named Joseph Groia to defend him. And what followed in Phase 1 of this trial? Wow, it became incredibly toxic. The whole thing ground to a near standstill amidst sarcastic outbursts, huge disputes over thousands of documents, and clashes over evidence. Groia repeatedly accused the prosecutors of using a conviction filter and having this win-at-all-costs mentality. He alleged they were actively trying to deny his client a fair trial. Both sides basically dug their heels in, creating a deeply, deeply hostile atmosphere. Moving on to Section 2, Civility versus Resolute Advocacy, the philosophical dilemma. Let's just zoom out from the specific drama of the Brie X trial for a second to frame the core tension here. It's really fascinating to look at how these two opposing yet completely necessary forces interact. On one hand, you have civility. It ensures peaceful dispute resolution and keeps the justice system from literally imploding on itself. But on the other hand, you have resolute advocacy. Lawyers absolutely must fearlessly raise every issue to protect their clients. Especially in a criminal context, defense lawyers often act as the final frontier standing between the lynch mob and the accused. They cannot be intimidated into silence. Now, I'm just going to fast forward you through the massive procedural history of this case, because this saga spans nearly 2 decades. The trial kicked off way back in 2000. Fast forward to 2009, the Law Society initiated disciplinary proceedings against Groia for his courtroom behavior. By 2013, an appeal panel actually suspended his license. And finally, the whole thing culminated in a 2018 Supreme Court of Canada decision. Okay, so to understand why Groia was fighting so hard, we need to define a legal term of art: abuse of process. This refers to prosecutorial conduct that impairs trial fairness and compromises the entire integrity of the justice system. Now here's the kicker. When a defense lawyer believes this is happening, they actually have a strict legal duty to expose it. Groia felt compelled to fiercely attack the prosecutor's actions because he genuinely believed an abusive process was occurring against his client. Let's move to Section 3 to see how this builds. The test for incivility. The appeal panel's approach. To evaluate Groia's actions, the Law Society Appeal Panel had to create a structured legal framework. And here is the multifactorial context-specific approach they developed to judge when a lawyer crosses the line. Step 1 involves looking at exactly what the lawyer said. Step 2 steps back to evaluate the manner and frequency of the behavior, like was it just an isolated incident or a constant barrage of insults. And Step 3 considers how the trial judge reacted in the moment, because after all, the judge is the one actually managing the courtroom. We're going to focus heavily on that first step right now, what was said. The panel established that any attack on another lawyer's integrity has to clear 2 specific hurdles to be acceptable. First, it must be made in good faith, and second, it must have a reasonable basis. Speculative or completely baseless allegations cross the line into professional misconduct. And this rule is absolutely essential, because a lawyer's reputation for integrity is their most valuable asset, and baselessly destroying it is deeply harmful to the system.
Which brings us to Section 4, Good Faith and Reasonable Basis, the crux of the Supreme Court appeal. This is the most crucial part of our explainer, where the Supreme Court of Canada steps in to dissect exactly where the Law Society went wrong.
The core of the issue really comes down to an honest but mistaken legal belief. The evidence showed that Groia's hostile attacks on the prosecution stemmed from his sincerely held but completely wrong understanding of the law of evidence and the prosecutor's role. He genuinely thought the prosecutors were legally required to introduce certain documents, and when they didn't, he accused them of misconduct. So he was wrong on the law, but he was honest in his belief. And this brilliantly illustrates the difference between the two prongs of the test, which actually function entirely independently. The good faith inquiry asks what the lawyer subjectively believed. Did Groia actually believe the prosecutors were cheating? Yes, he did. But the reasonable basis inquiry examines the factual foundation underpinning the allegations, regardless of whether the lawyer's legal theory was actually correct. The Supreme Court pointed out that the appeal panel made a highly unreasonable error here. You see, the panel accepted that Groia acted in good faith, but then they used his honest legal mistakes to conclude his arguments lacked a reasonable basis. The crucial takeaway from the Supreme Court is this. The question for incivility purposes is not whether Mr. Groia was right or wrong on the law.
All right, let's look at the final resolution in Section 5, the Supreme Court's verdict, applying the law to the facts. Let's see how the court applied this legal test to his actual behavior.
The Supreme Court outlines some critical contextual factors that the appeal panel basically ignored entirely. For instance, at the time of the trial, the law surrounding abusive process was actually still evolving. That kind of explains why Groia raised it so frequently. Plus, the trial judge initially took a very passive, hands-off approach, failing to correct the behavior early on. When the judge finally did direct Groia to stop his barrage of allegations, Groia largely listened and modified his behavior. In fact, the entire second phase of the trial proceeded without incident. So the manner, frequency, and judge's reaction actually weighed heavily in Groia's favor. Furthermore, the Supreme Court explained that it is not professional misconduct to advance a legal argument that is ultimately rejected. Think about it. If law societies start punishing legal errors as incivility, it would essentially act as a mandatory minimum standard of competence. Lawyers would be terrified of advancing novel arguments or forcefully challenging the state, and that would heavily chill resolute advocacy out of pure fear for their own careers.
So the crucial point really boils down to this question. If the legal position were correct, was the challenge warranted? As long as there is a factual foundation for their claims, then a lawyer isn't guilty of incivility just because their legal theory fails. Groia's factual foundation was that prosecutors were withholding documents. If his legal view that they had to submit them was right, his anger would have been totally justified.
Ultimately, the Supreme Court ruled impartially on the facts before it. They determined that the Law Society's finding of professional misconduct was completely unreasonable. Because Groia's allegations were made in good faith and had a factual foundation based on his understanding at the time, the Supreme Court overturned the misconduct finding. They officially cleared Groia. Which leaves us with a final, lingering thought. This case really highlights the razor-thin margin between necessary, zealous defense and sanctionable incivility. If regulators enforce civility too aggressively, will the fear of disciplinary action silence the next fearless advocate? Maintaining that delicate balance between a polite courtroom and a vigorously defended client, well, that's going to be a profound challenge for the future of our justice system.